evening, everybody. Hello and welcome to the Refugee Studies Center, the last seminar in our Michaelmas term series. Now we're ending the term with a very creative and a very thought-provoking launch event, a special edition of Refugee Survey Quarterly entitled Rewriting Refugee Law, Centering Refugee Knowledges and Lived Experiences. Joining us both from Oxford and, as you can see online, is an international panel of editors and contributors who will share their reflections on judgment rewriting as a way to facilitate refugee-led and co-ed research. Now, as we hope to spend as much time as possible engaging with the work and with the authors, I'm not going to be introducing all of our speakers. I'm going to hand it over to Kate to take things forward. What I would say, though, is that we have full details about the special issue and all of our speakers this evening on the website, so do have a look through and engage with the special issue itself. Thank you so much, Professor Kate. Over to you.
Thank you so much. Thank you to the RSC. Thanks to Catherine and Annalise for the opportunity to deliver this seminar. I'm at the Australian National University now, but I'm a graduate of the RSC, so it's always delightful to come back. So the seminar today serves two purposes. The first is to launch the special issue, see if I can get it up, which was, so this was published very recently in the Refugee Survey Quarterly, so issue 2 of this year, and thank you to the RSQ for being supportive of our somewhat experimental project. But the second is to critically reflect on the project methodology and discuss the next phase of the project, which we'll talk about. It goes a little bit beyond refugee law. So what I'm going to do today, I'm going to introduce the project and then going to hand over to Veronica to speak about some of the intellectual and ethical issues we have to navigate as project leaders doing a refugee-led or co-led project. And then I'm going to hand over to the authors, some are here, some are online, to discuss their papers very briefly and to give their reflections on the project methodology. So some of the authors are already published in the special issue and others are working on pieces to be published in the next phase of the project. So moving to the project itself, this project was very much a response to nothing about us without us, a phrase borrowed from disability advocacy, calling for refugee-led research in the field of refugee and forced migration studies. So as a group of refugee law scholars, and law perhaps being a conservative, exclusionary and elitist discipline, we wanted to explore the methodological possibilities of doing refugee-led or co-led research in law. So to do this, we drew on and developed feminist judgment methodology. So this is a methodology where a scholar takes a court decision, critiques it from a feminist perspective, and then goes further and actually adopts the judicial persona and rewrites that decision. So they can stay within the original bounds of the legal frameworks, they can come to a different decision, they can draw on different real or imagined alternative frameworks, and they can also make changes to the expression, the language, the judicial tone. And since their emergence in the 1990s, these feminist judgments projects have been extended to include, for example, queer judgments projects and Indigenous judgments projects. And our project was very much inspired by Nicole Watson and Heather Douglas's Australian-based Indigenous judgments project. And in this project, they developed a model of co-authorship whereby they paired an Indigenous scholar with a non-Indigenous scholar to rewrite a seminal and they use this model of co-authorship as a way to foster co-learning. So we wanted to develop judgment rewriting further by having scholars with a refugee background or lived experience of displacement to rewrite refugee law judicial decisions. And to the best of our knowledge, this is the first project of it. So we adopted that model of co-authorship. We paired where we could, where it was appropriate to do so. We paired scholars with a refugee background with scholars of refugee law who didn't necessarily have any lived experience in displacement. And we did this to foster co-learning, but also to open up the possibilities for interdisciplinary research, because we did find that a lot of judgment rewriting projects very much remained within the bounds of the legal discipline. And so being inspired by an Indigenous judgments project and all of us, all of the project leaders being based in settler colonial societies, we are really highly aware of the unfair and discriminatory workloads that are often put onto Indigenous academics and minority scholars. So we tried our best to adopt a model that pushed back against this. So alongside myself and Veronica, we had 3 other project leaders, Dr. Eve Lester, Dr. Jessica Hambley, and Associate Professor Matthew Zagor. And we also had an advisory board of scholars. So that included Nigel Newen, Professor Olivera Simic, and Dr. Tina Dixon. And as a way of pushing back against this unfair and discriminatory workload, what we did is the project leaders, such as myself, without a refugee background, we agreed to do all of the time-consuming, laborious, and frankly unsexy work of leading large academic projects. So we did that as a way of freeing the leaders of the project who do come from refugee and minority backgrounds, freeing them from these administrative burdens and giving them the time and space to shape the project intellectually. So just to give you some examples of the intellectual and policy contributions the project has already made, I'll briefly talk about the articles in the special issue because there's plenty here to present today. So Naraja and Jessica's piece, that is I know it might be hard to read for those in the back, but the last one there. This is, I think, a really rich example of the interdisciplinary possibilities of judgment rewriting, because it brings together Naraja, who is her expertise lies in the medical fields of counselling and trauma, and Jessica, who's one of the leading socio-legal researchers on refugee law decision making. And they take on the case of S99, which is a case about sexual violence on Nauru on one of Australia's offshore processing centres. And they stress that the original judgment, it's 529 paragraphs long, and yet the woman's voice is totally drowned out by legalese. So they take a trauma-informed approach to rewriting the decision. In doing so, they give S99 a name. They call her Sarah, and they write the judgment as a conversation where Sarah gets to tell her story in full, and the judgment is directed to her. This is not an ordinary judgment, which tend to be written for the lawyers or the potential appellate courts. And what I think is really innovative about this project is that we all know that court processes for refugees are re-traumatizing, but this piece gives us a way forward to do trauma-informed decision-making. And off the back of this, Naraja and Jessica have already been invited to do workshops with refugee law decision makers in Australia for how do you do trauma-informed refugee law decision making. Victoria and Bridge made the very brave made the very brave decision to rewrite MSS, so a seminal case, so much scholarly attention. But their rewrite does really add a distinctive perspective, I think, not only to MSS, but to refugee rights more generally, because they remind us that what we as refugee law scholars see as a legal victory here, the seminal landmark case, was not at all a meaningful victory for MSS because he was transferred to Greece anyway and we don't know what became of him. So they imagined the possibility of the European Court of Human Rights granting an interim measure, and they imagined the alternative outcome for MSS, but also the alternative outcome for the Dublin regulation if this was done, and they argued that there were legal grounds to do so. Samuel and Murizi rewrote a series of forced encampment cases in Kenya. And the piece is really interesting because they really reflect on what does it mean to write both from scholarly expertise, they're both lawyers, but also from lived experience. And they have different lived experience in Kenya. Samuel as a former Ethiopian diplomat and Murizi as a refugee. And they bring to the fore 2 issues that I think existing scholarly analysis of this forced encampment is really ignored. And the first is the underlying securitization of refugees in Kenya. And the second is the court's dogmatic approach to procedure, even when, and I quote, cases involve the fate of thousands of refugees. So looking at the contributions here, I think it's important to put feminist theory into practice. Let's look beyond the bounds of the special issue. It's a bittersweet moment to be launching this special issue because alongside the articles here, there were, of course, articles that were very much part of the project that never got to be submitted for publication. And most of these were from scholars by scholars who were either from or based in the majority world, who did not have the stability of employment or living conditions conducive to finalising academic work. And some of the refugee law scholars involved in this project had to pull out for reasons directly related to their persecution. So on this note, we want to be honest about the fact that feminist judgments methodology, which is very much an attempt to break free from traditional scholarly barriers and power asymmetries, that can actually end up reproducing them in some instances. So I'm going to hand over now to Veronica, hopefully, and she's going to continue the discussion of the critical reflections of the intellectual and ethical challenges of trying to do refugee-led or co-led research, especially in the field of law. So hopefully I'll be able to get the Zoom back up. Veronica, over to you.
Thank you, Kate. Thank you, RSC and all the organizers for putting the event together. Now, you can go ahead and stereotype me as the angry Black woman. I honestly don't care, but please hear me out. I know it is not easy to decenter whiteness in the academy, especially at RSC. So please brace yourself and listen to me for the next 4 minutes. I'm going to very briefly discuss the ethical and intellectual issues of challenges that confronted the 5 core editors, with me being the only one with lived experience of being displaced. First, the decision for all authors with lived experience of displacement to we give them the opportunity to self-identify based on pure trust. It was simple as that. We are not police officers or immigration officers armed with the power of discretion. So therefore, we did not ask for proof or stories of displacement. Some authors chose to share their stories willingly, and we welcome that. Second, the assumption that scholars with a refugee background are biased and emotional, hence cannot be objective or without merit because they don't have the so-called academic qualifications. I find that personally very arrogant and double standard. I bought into that nonsense and ended up with 6 freaking academic degrees today, knowing fully well that many with a third of the qualifications that I have without any lived experience of being displaced are flaunted as experts of refugee issues. For us, co-authoring with those who have refugee background was both ethical and a mandatory thing to do. Third, there is a similarly inescapable dominance and hegemony, homogeneity of minority world law and jurisprudence. This excerpt from the introduction captures how staunch the beast, and what I call the beast is the common law system, and that's my own term. So I quote from our special issue introduction. In the special issue, we set out to achieve geographical diversity in the judgments the authors have chosen to rewrite. One of the reasons for this is that the field of refugee studies has been rightly criticized for ignoring jurisprudence from outside the global north or the minority world. However, as noted above, all but one of the judicial decisions considered here emanates from the minority world. While our project seeks to respond to this critique, we see that our goal is inherently constrained by the strong minority world orientation of both international refugee law and academic publishing, and more particularly, minority world judicial decision-making. We also see here a direct correlation between highly technical and developed jurisprudence emanating from jurisdictions of unwelcome, preoccupied with border control and exclusion. This contrasts starkly with majority world and autochthonous traditions of hospitality. This basically, we are saying that there is a dominance coming from the minority world, which is Western society, and it dominates and take over any kind of decision or any kind of refugee jurisprudence coming from the majority world, which is the so-called global South. Fourth, the promises of breaking free from law that feminist judgment methodology promises, and yet the pain associated with inescapable dominance of Western common law is reflected in another paragraph that we wrote in the introduction, and I quote, "There is a lightness of touch and a freedom in being able to recraft a judicial decision in new and imaginative ways. But as these rewrites show, there has also been a pain in working within legal frameworks that are deeply technical and inherently silencing." I won't take any more time, Kit. I'll pass it back over to you.
Thank you, Veronica, so much. And just to add to one of Veronica's reflections about the assumptions that writing, scholars with a refugee background or writing from lived experience is inherently unacademic. When we put out an open call for papers, and we got a lot of excitement about this project, a lot of excitement, a lot of people wanting to be involved. But when we went to approach different publishers, we got a lot of shut doors, and we got a lot of shut doors on the basis that this is maybe for a literary magazine or at the best an edited collection, but it's certainly not worthy of a peer-reviewed academic journal. And Veronica, with her experience, absolutely saw this coming, and I got a bit of a slap in the face because I just wasn't expecting that reaction at all. And so again, thank you to Refugee Survey Quarterly for sort of backing us on this. But that's some of the issues that we've deal with this project. The assumption that it is unscholarly, unacademic, biased, and emotional. So what I'm going to do now is hand over to Dr. Saba Vasefi. So Saba is from the University of Sydney, and we are actually co-authoring a paper together that's going to be published in the second phase of the project. So I'll hand over to her now.
Thank you so much. Hello, everyone. Thanks, Catherine, for having us tonight here. In general, a court judgment captures a particular moment in a refugee's life. If the case is decided in the refugee favor, their ongoing harms often fade from public and legal scrutiny. This raises the question, how should the law, through judicial pronouncement, articulate the structural violence inherent in state-sanctioned refugee externalization regime, while also accounting for the profound harm, grief, and resilience experienced by refugees subjected to extrajudicial displacement system. In our study, we draw on the concept of structural injunctions in which courts retain ongoing supervision of a case to ensure long-term compliance with their orders. Commonly used in constitutional and environmental law, structural injunctions could act as a tool for continuous oversight in refugee cases. By incorporating such mechanism, court could ensure that the harms refugees endure, especially those related to systemic violence and displacement, remain under sustained judicial review. In our study, we focus on Iranian refugee women and non-binary individuals who are evacuated from Australia's offshore processing center on Nauru to Australia due to urgent health needs. We explore how structural injunctions could support the ongoing monitoring of the harms they face. Through in-depth qualitative interview, we examine their lives before and after the transfer, with a particular focus on a persistence of gender-motivated persecution. And I am going to argue these women and non-binaries, they are exposing to continuum of gender apartheid from Iran to Australia's offshore detention regime. And I'm going to define the notion of gender apartheid into both contexts. Additionally, we aim to identify which harms should remain under judicial scrutiny and which aspects the refugee prefer to keep private. By collaborating with the participant, we seek to envision a judicial response that incorporates their own terms and concepts. We expand the conceptualization of violence within a state-sanctioned extraterritorial asylum regime by examining not only isolated incidents, but also underlying structural sources of harm. Our revised judgments seek to recover that the often silenced human dimensions challenging the reductive, pathologizing depiction of refugees as passive victims. By situating the decline in their mental health within broader structural conditions and emphasizing their agency, self-advocacy, resilience, we critically contest the dehumanizing, medicalized framework within this context. This approach advocates for a narrative that affirms refugees' autonomy and capacity for survival, resisting their reduction to mere objects of harm. These often excluded forms offer more personal, emotional, and authentic accounts of harm, providing a fuller picture of refugees' experience and agency. These testimonies allow refugees to convey the depths of their suffering in a way that clinical or legal language cannot, offering a richer, more humanized narrative. Judgment writing methodology presents both advantages and limitations. Its primary benefit lies in structuring complex refugee experiences, incorporating alternative testimonies such as poetry, letters to capture emotional and psychological dimensions of displacement. And with the permission of a woman that I was working with her over 5 years, while she was living in a tent on Nauru, I am going to recite one of her poems that I translated from Persian to English to depict the single dimension of her suffering inside detention regime. Do you remember me? I am the mourning mother who is left alone on the island of abandonment. Like a wounded crew, I was bleeding, scratching the soil to find a grave for my son's stateless corpse. My 26-year-old son, an athlete, a dentistry student, had his last breath in the Mali government tents, closed his beautiful eyes to injustice under deadly heat. Even death did not save him from cruelty. I was powerless to bury him, entrust him to eternal peace. They kept a young corpse in the fridge for 26 days inside a container near a place I was living as a mother. To find the cause of death, to detect the killer. For more than 4 months, his lifeless body remained in a fridge in Brisbane. They did not permit a burial, as his dead body was still a stateless number. They ripped his body without my consent. For years past, I still don't have the autopsy result. They did not smell blood on their hands. In the camp, I become a number. In the court, I remained a number. I always said, if any harm befell my children, I would not remain silent. Where hope does not exist, the pen can stitch us to life. So I write not as a number or a defeated woman, but a woman in resistance. Thank you.
And this poem is part of a collection of poems that a project that Saba is running, so I'm sure she would be happy to provide links to the published works of the poem. But what we might do is alternate between in person and online. So Colin, if I can hand over to you. So Dr. Colin Gray from Queen's University.
Okay. So thank you, Kate. Thank you to the RSC and to the project leaders on this collaboration. I also want to thank Veronica, who is my co-author and collaborator on this piece. Over several months, Veronica and I had many Zoom conversations in which she educated and challenged me in a way that I think is going to make an enduring mark on my scholarship. So our article rewrites a decision by the Supreme Court of Canada. The decision is called Faiblesse, And Febles is the most recent Apex Court decision interpreting Article 1FB of the Refugee Convention. Article 1FB is one of the exclusion clauses of the Refugee Convention, and it specifically excludes people from refugee status if they're found to have committed serious non-political crimes. In Febles, the Supreme Court had to figure out how to interpret the requirement of seriousness in Article 1FB. And what the court found was that post-offense considerations, like whether or not someone has served a sentence, the passage of time, can't come into play in determining whether or not an offense was serious. So, for example, if someone committed an assault 50 years ago, served their sentence, they would still be excluded under Article 1FB 50 years later. So we argue in our piece that the Supreme Court's decision reflects, in part, the unjustifiable importation of migration control considerations into the interpretation of the Refugee Convention. And so exclusion is thereby made to contribute to racialized patterns of globalized migration control, right, under which race and place of birth contribute to determine life chances. Having said that, we don't actually argue for the elimination of Article 1FB. Elimination of exclusion, we say, would actually disregard the perspective of both majority world states and majority world citizens. Instead, we propose a different interpretation under which there's an initial, a heightened requirement for the evaluation of seriousness, and in which considerations of expiation have to be taken into account. So Kate asked us to give 2 points, sort of discussions of the sort of strengths of this methodology and then some of the challenges. And so I just want to briefly reflect on two aspects of the methodology that I found particularly valuable. The first was that I found it very powerful in conversation with Veronica to be forced to ask about sort of every potential interpretive move, both from the perspective of the majority world. And it's really sort of this sort of feature of the methodology that led us to argue for a different interpretation of Article 1FB rather than the sort of elimination or abrogation of Article 1F, which had been my starting point. And then the second strength of the methodology, and this is perhaps something that comes out more in a slightly more traditionalist version of the application of this methodology, like in our piece, is that it allows you to show that your academic criticism is actionable, right? You can actually write sort of the propositions that we put forward can actually be put in the form of a legal judgment. And that means that the legal resources for the court to have come to a different conclusion were there. And I think that that shows, hopefully in a powerful way, that decisions like Febles are not just a failure or not just instances of deficient legal reasoning. They actually represent failures in judging and failures in imagination, right? And then the last point I'll just make about sort of what I consider to be a challenge of this kind of project, or it's sort of a worry, and I know that Veronica disagrees with me about this, but the worry is that this kind of scholarship may have less of an impact on the jurisprudence itself. At least in Canada, no one really pays attention to even dissenting opinions. A decision like Febles was decided 10 years ago, and I do have a worry that sort of the courts themselves will pay a little bit less attention to this form of scholarship than sort of something that might appear in an article, and that might be a little bit more forward-looking. So that's it, and I think I'm in under time.
Well done, Colin. Thank you so much. So I'm now going to hand over to Sitarah Mohammadi from Monash University to give some reflections on the piece that she published in the Refugee Survey Quarterly.
Thanks, Kate. Can I start off by acknowledging the work that Kate and other leaders of this project have done in enabling the special issue, as Kate mentioned earlier, the challenges that were confronted, but ultimately were overcome in terms of putting the special issue together. And I also appreciate the RSC and colleagues who are hosting us here tonight and who have enabled us to gather here to talk about this special issue. I would also like to acknowledge my co-author, Dr. Maria Sullivan from Melbourne, Australia, who was very, very kind enough to co-author this very, very special article with me. So our article is entitled Rewriting Internal Relocation from a Refugee Perspective, the Lived Experience of Refugees in Afghanistan. We chose internal relocation as a subject for our article because it is a problematic and controversial principle of international refugee law, which we believe frequently is applied without due consideration of the practical experiences of refugees. Internal relocation provides that refugees may be returned to their country of origin if they can relocate to, and I quote, a safe part of that country where they would not have a well-founded fear of persecution. In most jurisdictions, this principle is somewhat tempered by applying a reasonableness test. This test aims to reflect that in some cases it may be possible, rather impossible, to require a refugee to relocate to another part of that country of origin to avoid persecution. However, the reasonableness test is not always considered part of relocation in most cases. Moreover, it aims to bring an objective standard of reasonableness, which can be critiqued from a number of bases. Our article aims to contribute to these central debates by revisiting the application of internal displacement using an Australian case from 1994, which is the fundamental, which set out the fundamental test for relocation by being the first landmark Australian case in 1994. In our paper, we argue that the principle of internal displacement should be reassessed on, on a case-by-case basis, and suggest that it should not be applied in post-conflict or ongoing conflict situations, such as Afghanistan, where the political and security conditions are unstable and unpredictable. We contend that re-evaluating the internal displacement principle allows decision makers to understand better significant socio-political and historical conflicts affecting groups like the Hazaras in Afghanistan. In terms of some of our advantages or benefits of our methodology, by incorporating the lived experience of a refugee, so myself, having fled the persecution of the Taliban in the late 1990s, our methodology provides a more humane and grounded perspective of refugee law, moving beyond just abstract legal concepts to real-world implications of the international principle. This approach, we hope, ensures that the refugee experience, which is often overshadowed by theoretical and procedural debate, is central to the legal analysis. By rewriting an actual refugee tribunal decision to reflect refugee realities, we directly engage with how current legal standards might fail to consider the nuances of refugee experiences. This could potentially push legal systems, including that of the UK and Australia, to reconsider the assumptions underlying principles like internal relocation. As a challenge, whilst the lived experiences of refugees add immense value, they are inherently, to an extent, subjective and can vary significantly across individuals and contexts. The challenge lies in ensuring that this subjectivity does not lead to overgeneralizations about the refugee experience or obscure the complexities within this group. Shifting the focus from legal theory to refugee experience may potentially at times risk challenging established legal norms, which may face resistance from those who prioritize the consistency and objectivity of legal principles. Nonetheless, we note that more work is needed to reevaluate the internal displacement test and its impact on the human rights of returning refugees. In particular, we highlight the need for further analysis of whether restrictions on freedom of movement should be considered in internal displacement decisions, and if so, how this should be done, how this should be better addressed. Lastly, we hope that this approach will encourage a reassessment of these contexts and lived experiences of other refugee groups, ultimately leading to more informed and fairer decisions regarding the protection needs of refugees.
Thanks, Sitarah. I'm going to hand over to Mehrnoosh Farzamfar from the University of Turku.
Hello, can you see me? Can you hear?
Yeah.
Yeah, thank you very much, Kate. And also I would like to thank the seminar organizers at the RSC. This is the right place to also mention my co-author, Magdalena Kemek. She is the professor of public international law in Finland at Åbo Academy University. And also I should mention Matthew and Eve. I don't know if you are sitting there or if they can hear. I would like to sincerely thank your critical comments on our earlier version of the work, because it really helped the work to come to the existence that it looks today. So that being said, for today's presentation, I would like to share with you the work that Magda and I have been doing for this project on rewriting the case of ND and NT versus a...
Sorry, Mehrnoosh, you are frozen. I don't know whether it's on our end or your end.
Hello?
Yes, you were frozen, but you're now back. So you just finished where you announced the case that you're looking at ND and NT.
Yeah. So the case is from the ECTHR. It concerns Article 4 of Protocol number 4 of the Convention on Prohibition of Collective Expulsion. At the chamber level, the court kept to a very dogmatic and theological definition of the term expulsion and collectiveness. Therefore, it ruled in favor of the applicants. However, at the Grand Chamber level, we see a huge turn of the position of the court. We see that the factual evidences that were submitted at earlier stage and thereafter at the Grand Chamber stage were ignored by the court, and the concept of security concerns of the EU were brought to the forefront, and the concept of culpable conduct of the applicants, meaning that because the applicants chose to approach the border between Melilla and Morocco in a mass manner, therefore their rejection and return to Moroccan territory is the result of their wrongdoing, because they have benefited from the factor of surprise, and they call it en masse entrance. So here I would like to straight go to the challenge of rewriting this judgment. The challenge posed itself at two levels to us. The first is that we had to ignore the factual evidences, overwhelming factual evidences that were submitted, and how to combine it, the answer to this question, in our rewritten judgment. So we decided to take a post and decolonial approach to EU migration law. So the premise in this writing is that EU law indeed comes from its colonial and nowadays neo-colonial legacies. Therefore, the judges at the Grand Chamber level decided to completely ignore and put aside the facts that were presented in the case. So by taking a post and decolonial approach to EU migration law, we try to explain this deliberate ignorance by the court, the challenges and opportunities that this critical approach poses for this writing project and future work is quite significant. And we're considering the beginning of an academic and hopefully practical implication for future. Our rewritten judgment has come out in the form of a dissenting opinion, thanks to the editors of the co-editors, Matthew and Eve, because of their suggestion. This form of rewriting has allowed us to disagree with the majority of the judges' finding, and showing that how this approach of the court, based in deeply colonized history of EU migration law, is problematic, and therefore the law and practice must go beyond that approach. I hope I managed to keep under the time that you were keeping, Kate.
Thank you so much.
Thank you.
Mehrnoosh, so I hand over now to Dr. Irene Antonopoulos from the Royal Holloway University.
Thank you. I set up to discuss Loizidu and Turkey from the European Court of Human Rights with my co-author, Dr. Konstantinos Yallouridis. And we're coming from a background where we are both recognized as refugees in Cyprus, although we have never actually experienced the Turkish invasion of Cyprus. So we are the third generation, I would say, of Cypriots, but we're still recognized as refugees in the face of the law in Cyprus, but also psychologically. So our main concern was that we're coming from as two people where their identity is connected to displacement to actually discuss this case. And our concern was the interpretation of home from Article 8 of the European Convention on Human Rights. And crucially, that Loizidu was not living in the house in the occupied part at the point of the invasion. Therefore, the court felt that there was no human rights claim to that particular home after the invasion. So our issue, I guess, was there is no kind of concept of laws and psychological laws in the way that the European Court of Human Rights interprets home in such cases. The way we set out to do it was, in order to avoid bringing our own perspective in it, was to see whether Loizidu's perspective was identical to ours. So we went and asked her. The challenge of this was the ethics, of course, approval, because we are going to ask somebody how they felt about losing their home. And although she's very, very used to giving interviews, for example, about this, she has spent her life working on this. She became extremely emotional when we asked her to define what is home to her. And she did say she wasn't living in the house itself during the invasion, but she considers it at home, as well as her children and grandchildren consider it as home, although they have never seen it. And that matches our own experience. And so there were ethics issues there to consider because we were asking people how they felt about this. What we identified, of course, which is the benefit of this methodology, was that there's a disconnect between the public perception of their identity. So they kind of recognize themselves as refugees, although we're talking about internal displacement. So there was a use of emotive language throughout the years in Cyprus. So there is a bit of disconnect of understanding of where exactly is their legal status. And that part became particularly evident when we talked to lawyers that participated in negotiations between the Turkish and Cypriot authorities about the ownership of properties in the north part of Cyprus, which was the occupied part. And we, of course, recognize that there's a disconnect between how people feel about these homes, the emotional connections with these homes, the cultural elements that are connected to these homes, and the sense of family, and how the European Court of Human Rights sees homes in a more, I guess, dry sense. So our main kind of argument is that potentially when there's laws in the sense of displacement, the court should actually consider those connections to the home rather than the house and the property itself.
Thank you so much. And Irene did this while she was on maternity leave, so it was, we thank her very much to her commitment to the project. So now, last but certainly not least, I'll hand over to Ayesha Riaz from the University of Greenwich.
Thank you, Kate, for commissioning this special issue, and also to the organizers of today's seminar. So I rewrote the case of detention action and Lord Chancellor. So just a bit of background about myself. I used to work at Duncan Solicitors for many years, and I left because of the bureaucracy of legal aid work, the low rate. So this case was about the detention duty advice scheme that operates in detention centers. And by virtue of this scheme, what happens is that detainees usually get about 30 minutes of free legal advice and assistance in detention centers. So prior to 2018, only 8 or 9 legal aid firms did this sort of work. And I was working at the firm that did this sort of work from about 2012 to about 2019. But what we saw after 2018 was that the legal aid agency opened the tender for many other firms to do this sort of work. So most of the new firms that got this tender actually sadly didn't have much experience of doing legal aid or detention work. And when you're looking at immigration detention, it's a very specialist area, and you come across clients that are very, very vulnerable. So the legal aid agency just allowed many other firms who had very little experience of doing such work to kind of like, do detention work. So what we saw was that, the quality of advice actually deteriorated, and it was very, very poor, the quality of advice that the detainees received. And as a result of all the bureaucratic, elements that come with doing this kind of work and the low rates of pay, we noticed that a lot of the newer firms eventually dropped out. So this was my article. I've got one point about some of the benefits. I've got quite a few, but I'll just mention one of the points that I've jotted down about the benefits of this kind of methodology. So so as someone who has had, quite a lot of first-hand experience of dealing with the legal aid system in the UK, what I saw was that as a result of this project, it was very useful to convey how I think the publicly funded asylum system should operate in the UK. And this, as a result of this article, I got a chance to actually, talk about a lot of other things: bureaucracy, the low rates, the micromanagement of legal aid asylum solicitors. So I thought it was very beneficial, and I actually did send it to a lot of my friends who are still in practice. So, and the challenges I thought was, because it was a very unique project, sometimes I found that it was very difficult to recommend, changes to the system, because sometimes I felt like that, like, for example, I said the rates of pay need to increase. Yes, they have not increased since the 1995 legal aid asylum solicitors. And I was they were asking for a lot of justification. And the justification was, look, the rates have not increased for publicly funded asylum solicitors since 1995. That was one of my major, recommendations. But so sometimes it was like, I found that it was, because it was not a traditional kind of article, it was rewriting a judgment that was passed by the High Court. And sometimes, I found it difficult to advocate reforms because of, the reviewers' feedback. But in the end, it worked out okay. So thank you very much. I hope I'm within my time frame.
Thank you so much, Ayesha. I see that we have 8 minutes to go, so we're just going to very quickly conclude before we go to questions. I'm going to hand back over to Veronica now, who's going to speak very briefly about our ideas for the second part of the project. This was always going to be a 2-part project. We felt there was a real need to have the first part of the project very much specifically focused on refugee law. But Veronica, I'll hand over to you for giving ideas for what we're going to do next, and we're still interested in contributors if anyone's interested to take part. Veronica?
Thank you, Kate. Very briefly, we're really hoping we can get feedback from people and comments, because for me, that's the most important part of doing this kind of work. So I'm going to be really brief, and hopefully we can get a question or two from the audience, or statements or comments. Basically, it takes a lot of toll on us as editors, especially those of us with lived experience, to do this kind of work. I come to this work with not only the emotional experience that some of you dismiss, is the trauma that I live with, that is literally the fuel that inspire me to continue doing this work, because I just hate the fact that so many more young African Liberian girls are going through this kind of experience at the expense of some people who have no clue what it means to live this life, and literally exclude and dismiss them. So our plan is to continue to work in the form of a book, and we are hoping to pick up that project next year between January and February, because we are just really overwhelmed as well. Personally, I'm quite overwhelmed with a lot of requests and my own responsibility, but we will be sending out a call for book chapters. If you're interested, we'll share it with RSC, and those of you who would like to take on this mantle and continue to march up and tell Western court system that there's another way to think about law and teach law in a classroom, specifically regarding Colin's challenge about the fact that dissent is not even important for Canadian courts, but at least we can start reframing people's young law students' minds, how to rethink how you write judgments. So we're going to come up with a call for paper in January, February, most likely February. And this time we'll be looking at a book chapter, and we already have a number of authors that are lined up to contribute, but we still need more, and we want to continue this project. So I'll close my beaks and thank you.
Thank you. And yeah, and I just want to take this opportunity to say thank you to Veronica, who's just been a powerhouse and has really driven this project and contributed to it in so many ways, and in a lot of ways sort of kept us going. And the next stage of the project is looking at refugee justice alongside questions of indigeneity and displacement in the Indigenous context. So really trying to bring our refugee rewriting project together alongside an Indigenous justice rewriting project as well. So thanks.
Thank you very much.